I can see. And so we'll just start off now. And the last session is called 10 Years On, Have Emergency Arbitration Procedures Lived Up to the Promise? My name is Chanaka Kumarasinghe. I'll give you guys a more full introduction in about 10 minutes or so. But I'd like to hand you over first to my co-host, Peter Wolrich, to introduce himself and give his introductory talk session.
Well, thank you, Chanaka. Indeed, my name is Peter Wolrich, and I'm a partner in the Paris office of Curtis Mallet-Prevost, Colton Mosley, and have spent my now fairly long career almost exclusively in arbitration, both treaty investor and commercial. And perhaps what's most relevant for this session, I served for 12 years as chairman of the ICC Commission on Arbitration, and in that role was a principal draftman of the ICC Rules of Arbitration, including the 2012 Emergency Arbitration Rules. So for better or for worse, you have before you the guilty party for drafting those rules. And when we see whether they've lived up to their promise or not, you can make up your own mind. This is a coffee shop session, so I have my cup of coffee here. And I'm supposed to tell you, so I will, that apparently this session is being recorded and will probably appear on YouTube. So those of you who speak and participate, and we very much hope you will know that this is a recorded session. So without more ado, let me sort of, in terms of the structure of this session, what Chanaka and I have come up with and propose is I'll give an introductory talk from a more abstract perspective or theoretical perspective on the question for this session. And then Chanaka will come in and give a preliminary talk on the more practical aspects of the emergency arbitration procedure. And then we would like to open up to you if any of you have been involved in emergency arbitrator proceedings under a particular set of rules or involving any particular jurisdiction behind. We'd like to hear from you, and the idea is that we would allot up to 3 minutes per person who would like to share with us their experience on emergency arbitrator, because in fact it's not easy to get that information because it's not public and it's hard to obtain. So we would appreciate that. I think it would be very valuable. After that, we'll move to a Q&A, and if need be, round it off with some questions back and forth between Chanaka and myself. So that's the game plan. And so let's launch straight into it. If any of you have any questions as this goes along, since this is a coffee shop and an interactive session, do raise your hand, and don't hesitate to interrupt either of us if there's a question you'd like to ask in the course of our presentation. So let's get started.
One note, Peter or Chanaka, I think you have to turn on our video. I think we can each have the option to leave it on, but I think you have to create that option.
Right, okay. Turn on your respective videos, right?
Yeah, when I try to do it, it says I can't start because the host has stopped it.
Ah, well.
Sorry, hang on.
It's not a big deal, but just if you're wondering why you can't see anyone, apparently it has to be turned on your end somehow.
Ah, okay.
Right, so if you kind of carry on,
Yeah, for sure.
All right, I'll carry on, and perhaps Victoria with Chanaka can find, now I see Glenn. How are you? Good, all right, so we get started. So the question for this session, indeed, is whether emergency arbitration procedures have lived up to their promise 10 years on. Well, let's start with some solid statistics from the ICC and see what that tells us. The ICC first adopted its emergency arbitration procedures in 2012. And during the 6-year period between 2012 and 2018, there were 80 ICC emergency arbitrator applications filed. So 80 applications in 6 years, which is considered by ICC, given the fact that arbitration agreements kick in over time, is considered to be a fairly decent number. However, relief was partially or fully granted in 23 of those 80 cases, and the full relief requested by the applicant was granted in only 8 of the 23 cases. And so what this means, of course, is that some relief was granted in less than a third of the 80 cases, and full relief, or the full requested relief, was granted in only 10% of the cases. Now, these statistics might lead you to think that the answer to our question is that emergency arbitration procedures have not lived up to their promise. You only get 10% of the cases with full relief, only 29%, to be more precise, with partial relief. Well, my submission to you is that they have lived up to their promise. But to understand why that is the case, we have to first get a clear idea of what that promise is and what that promise is not. And to move into that, let's begin with a definition of emergency arbitration procedures. And this definition comes straight from the 2019 ICC Commission report on that topic. And it looks like this. And the words may be backwards on your screen, I don't know, because of the mirror image. But anyway, it looks like this. You can obtain it for free on the ICC website, and it contains a goldmine of information on emergency arbitrator proceedings. So I highly recommend it to you. So let me now read you the definition from that report. Quote, emergency arbitration is defined as a procedure through which a party unable to await the constitution of the arbitral tribunal can seek to obtain urgent interim or provisional relief prior to or independent from an arbitration procedure on the merits, unquote. Now, that definition makes clear what emergency arbitration procedures are not intended to do. We'll start with that, then we'll go to what they are intended to do. First of all, they are clearly not intended to be mini arbitrations on the merits to enable a claimant to kind of smoke out an arbitrator on what the result might be, for purposes of perhaps settlement or perhaps intimidation. And also from that point of view, they are clearly not intended to be used as a form of harassment of respondents by claimants. For that reason, at least in ICC and in most of the other institutions, the fee for initiating this is high enough to, discourage random use of it. The rules cannot be used if the relief is not urgently needed and cannot await the constitution of the arbitral tribunal, and they cannot be used by a claimant who does not file a request for arbitration on the merits. So while it's independent of the arbitration, it has to be linked to an arbitration. Under some of the rules, you have to file at the same time. You have to file your arbitration at the same time as your request for emergency arbitrator. In the ICC, it has to be within 10 days of filing the application for emergency arbitrator. You have to file your request for arbitration. And of course, these rules cannot be used if there is no valid arbitration agreement that incorporates emergency arbitrator provisions. And in fact, you can see there are two aspects to this. One is jurisdictional. You have to have an arbitration agreement that incorporates emergency arbitrator provisions. In ICC, there is the opt-out concept, such that if you put an ICC clause, a standard ICC clause in your contract, you will have agreed to the emergency arbitrator procedures. The only way you can get out of it is by expressly opting out, which of course you may do. Now, the fact, I submit, Before that, let me mention, so that's the jurisdictional aspect. There's also an admissibility aspect, which is urgency. We talked about that. So you have to meet the jurisdictional requirement of an arbitration agreement and the admissibility requirement of urgency. Now, the fact that most of the emergency arbitration applications that did not produce results failed, I submit to you, is because the applicant did not comply with the requirements, either jurisdictional or admissibility-wise, for emergency arbitration to proceed. Now, what is then the promise of the emergency arbitration procedures? Well, they are intended to provide claimants or counterclaimants a way of obtaining urgent interim or provisional measures without going to a state court and without having to wait until the arbitral tribunal is constituted. And the following types of relief can be requested. There can be a request for an injunction, a request for a preliminary injunction to preserve the status quo, for example, to maintain a distribution agreement in effect pending the constitution of the tribunal. You could ask for specific performance under a contract, for example, an order to permit the sale of perishable goods. You can ask for an order not to cash a performance bond. You can ask for an order to transfer money into an escrow account, or a request for an anti-suit injunction to prevent legal action in state courts until the merits are decided. Those are the kinds of things that you can ask for. Now, the record shows that emergency arbitrators do grant relief when the requirements are met and when the relief is shown to be justified. And of course, the justification will always depend on the circumstances of the case, and the emergency arbitrator always has significant discretion in evaluating those circumstances. Typical factors that emergency arbitrators have taken into account would include such things as the risk of irreparable harm, the risk of aggravation of the dispute, the absence of a need to prejudge the merits, and so on. So in short, I think it can be said that the emergency arbitrator procedures have lived up to their promise of providing this type of urgent interim relief, but that a significant number of parties have not properly understood what that promise is. And so emergency arbitration procedures, let's not forget, they do involve a not insignificant amount of time and costs. And so as a result, applicants for emergency arbitration procedures should carefully study the requirements and the justifications for the relief they're seeking, and make sure that the emergency arbitrator will have jurisdiction based on a valid arbitration agreement, and that the threshold requirements of admissibility for granting the relief are met, and that there's sufficient justification for the particular remedy that's been requested. Now, further evidence of the usefulness of emergency arbitration procedures and user demand for such procedures is the fact that so many arbitral institutions have adopted emergency arbitrator rules. And since the question is 10 years on, let's look at the timing of that. The ICDR adopted such rules in 2006, so more than 10 years ago. The SCC and the SIAC adopted them in 2010, so 10 years on. The ICC and the Swiss Chamber adopted them in 2012, and the LCIA in 2014. Now, these various rules are quite similar, but there are distinct features. And so if you're in a particular, under a particular set of rules, if you're under the SCC rules or the ICC, you need to study carefully, particularly the admissibility requirements under those rules, to make sure that you're complying with the specific threshold requirements of the rules. In addition, the fees for emergency arbitration can vary considerably depending on which set of rules you're under. So in conclusion, emergency arbitration procedures can be of great benefit to claimants or counterclaimants. Of course, they are not particularly useful to respondents. That's not what they're intended to do. So it is a procedure that really helps one side and not so much the other. If the applicants comply with the requirements, they can indeed obtain urgent, interim, or provisional relief without going to state courts. Now, the record shows that there is a high rate of voluntary compliance with the orders or awards of emergency arbitrators, perhaps in part because respondents do not want to appear as failing to comply with an order at the start of the arbitration on the merits. However, if there is no voluntary compliance, it would be necessary to seek enforcement of the emergency arbitrator's order or award in national courts. Now, at the present, some national courts have enforced and will enforce such orders or awards, and some will not. And so it is thus important also for the applicant to determine the position of the national courts in the jurisdiction where that applicant would seek enforcement of the emergency arbitrator's order or award. Well, this concludes my brief overview of the question before us in this session. I would be very interested in hearing from all of you out there whether you think the emergency arbitrator provisions have lived up to their promise. But before we do that, I'd like to turn the floor back over to Chanaka, who will now provide us with some practical insights into the emergency arbitration process. Thanks for your attention.
Thank you very much, Peter. Hello, everyone. Thank you for joining the last session. My name is Chanaka Kumarasinghe. I'm a partner of the English law firm HFW. It's an international law firm. I've been based out of the Singapore office now permanently for the last 15 years. And before that, I worked in London. As I was putting this introductory talk together, I realized that I've been a partner now for 9 and a bit years. Next year is going to be 10. And of course, the title of this topic involves a 10-year period. And, you know, as Peter very much summarized it, you know, as the various institutes adopted the emergency arbitrator procedure, that has developed from there. So I would say it's lived up to its promise, and it's also sort of tracked my own 10 years to an extent. And the reason for that is because I work in the oil and gas sector. That's primarily where I work, and I primarily act for upstream contractors. So during those 10 years, I'm sure you guys can track the ups and downs of the oil price and the like, and you can probably imagine that there has been, over the last 10 years, plenty of urgent work that needed emergency arbitration relief. So over the last 10 years myself, it's been a mixture of having to seek orders before various emergency arbitrators, or alternatively, and there's been a fair amount of having actually to prepare for a potential emergency arbitrator relief before an emergency arbitrator. And for one reason or the other, we didn't proceed. One reason is the matter actually amicably settled. We came right to the edge, but we didn't have to pull the trigger. And the other reason is actually pretty much as people flag right now. Having looked at the evidence overall, having looked at everything, it didn't seem as if we were going to cross the necessary threshold requirements. And the advice to any client at that stage, at that very early stage, is don't chance it. Don't try one on just in the hope or expectation this might work. Because it's a very, very early blow and a very, very early loss, which is something that it just simply couldn't be afforded. So that's certainly been my reasoning over the last 10 years. And for the rest of my talk, I'm just going to share some practical experience with you. Certainly at the start of maybe about 7-8 years ago, when a client gives you that urgent call or when they come into your office, the client never comes in expecting you to say, look, could you appoint an emergency arbitrator? What are the prospects? The reality is a lot of clients unaware of exactly what an emergency arbitrator is, and they weren't even aware that they were actually existing in the rules that had been provided. So my job at that point in time is to quickly educate the clients in respect of the potential of the emergency arbitrator and what could be done. And, you know, I need to also quickly look at their law and arbitration clause to make sure it has those medical words, whether it's LCIA, whether it's ICC, whether it's SIAC, a forum that will give me the relief that I need. Another thing that clients do often come to when they do have a problem and they have an arbitration clause is this. They are often unaware that there is an emergency arbitration relief that can give them relief in a shorter period at 2 weeks, sometimes even less. They come to seek advice on the view that we've just told management that we're going to have to commit the company to 2 years arbitration, and we're going to be stuck with a 2-year arbitration. So essentially, there's a process of discussion and advice that goes on very quickly at those early stages, revealing to the clients what can be done. But once that message comes through very clearly to the client, it's almost like the promise has been delivered to a claimant in trouble. The claimant then feels, actually, there's some prospect here of me resolving this problem fairly swiftly and managing to extract myself or secure something very swiftly. So when I speak to the clients at that early stages, what I'm looking for immediately, I'm looking for the urgency. Like Peter mentioned, we've got to make sure we. And I also look to establish as quickly as I can what is it the client wants. And funny enough, when clients are in a tight spot, they're very, very clear about what they want. It's very clear at that early stage. If I could summarize it, either they need something, somebody has to do something so they can get something, or they need to stop somebody from doing something that would just cause them a lot of harm. So at its very high level, that's how I would summarize it. But still then, you know, I can see the client struggle, because the reality is, unlike going off to a high court judge, you have to start arbitration proceedings. I've noticed that actually that is probably one area where maybe the promise perhaps is a bit of a difficult pill to swallow, because it brings with it the potential, as I've advised clients, once it's started, if they also have a $50 million counterclaim, that counterclaim is going to be lodged, as a matter of fact. So you know, even though it's my experience that, you know, almost all of the emergency arbitrations that I have started have settled after the emergency arbitrator issues their award, that's really nothing I can bank on when it comes to give the advice. The advice is there is an arbitration, and it takes 2 to discontinue. So on a practical front, the exercise that starts immediately is this. It's gathering evidence. And my preferred way to gather evidence is to essentially get a witness statement sorted out as quickly as I can. Whether or not I use it, how much of it that we eventually use in the emergency arbitration proceeding, it remains to be seen. But there is a lot of work that we have to do at very, very short notice, as early as possible, to make sure that we're ready. Because once things kick off, it'll move very quickly. And another thing that is probably worth mentioning from my perspective is, although I sit in Singapore, I run an international arbitration practice out of Singapore. I have yet to do an emergency arbitrator application or international arbitration for a project in Singapore. It just doesn't happen. So that means, as we said, the remedies that we look to seek from a client involve them stopping them from doing something or making sure they do something. I need to also urgently speak to a local lawyer on the ground so that I can establish as quickly as I can how the local lay of the land is in respect of the sector I'm in, and any local knowledge I need to know when it comes to securing the orders that I need. And then just moving on to the final point. Once the emergency arbitrator is appointed, as I said, things will move fast. And the reason why you need to do a lot of prep work in advance is you need to know very early on what your prospects of success are. And those should be quite easy to establish early on if you've managed to gather your evidence. Because once the emergency arbitrator is appointed, there's no time to do any of that. And I've noticed two splinter tracks tend to develop. One is the splinter track dealing with the actual emergency arbitrator hearing. So the procedural telephone conferences, the submissions that are to be served, the hearing, they sometimes all tend to essentially take place by way of video conference, which is, when you think of the COVID world, it seems as if the emergency arbitrator procedure actually anticipated that. The second point that develops is suddenly you have got the other side's attention. And I think, like Peter flagged, it's not necessarily always the best procedure for a respondent, because the respondent always is caught off guard to one degree or the other. And since you have that attention, what happens is essentially without prejudice discussions start. And a settlement discussion starts. So you have two things going on at the same time. You have your legal proceedings, and you also have a settlement agreement. So if you sort out all your legal merits and your documentation and your submissions well in advance, you know where you're going, you can help your clients with the general settlement. And then comes the tightening, because you can expect, even in the long end of things, for the emergency arbitrator to hand down his award 10 days, certainly within 14 days. I've never heard it being any longer than that. So if there are settlement discussions going on in parallel, it's almost like who blinks first? Will you settle, or will you take your chances with the emergency arbitrator, who may well make things a lot worse for you? So, and that's essentially, if you wanted to sort of know in a snapshot, 10-minute snapshot, how it works as a matter of practice, certainly from my perspective. So thank you for that. So Peter, on that note, should we perhaps open it up to the panelists?
Yes, we'd be anxious to hear from any of you about your own experiences and whether those lived up to what you hoped for. Has anyone been involved in an emergency arbitrator procedure? Well, maybe not. Well, if that's the case, then does anybody have any questions they would like to ask, or any points they would like to open up a discussion on? I know this is the last session, and probably we're all at our last gasp. It's probably true for Chanaka and me as well. There's someone coming in saying we are all muted. And so, Chanaka, you need to unmute everybody somehow.
Right. Well, I thought that I did.
Well. I see Victoria's name at the lower left hand of my screen. Is there anything you can do to help us unmute? If you hear this.
Well, as far as the function says, okay, guys, could somebody can you unmute yourself now, the person who did ask a question?
Now
yeah.
I'm unmuted.
Right.
Ah, very good. So-
Whatever you did worked.
So has anyone got a war story to share with us? Let's go back to that.
Yeah,
I do not have a war story, but I have a question. Perhaps one of the main criticisms for why maybe emergency arbitration hasn't lived up to its promise has traditionally been that in some jurisdictions, state courts are reluctant to enforce emergency arbitrator awards, as they regard them as interim awards, and there are difficulties in some jurisdictions with enforcement of interim awards. So I was just wondering if maybe anybody could propose some resolutions to that difficulty. Can it only be resolved by those jurisdictions amending their arbitral laws, or could it be addressed in some other way by institutions amending their rules, or perhaps by UNCITRAL updating their model law? If you have any thoughts on that.
Yeah, I can speak a bit to that.
Yeah, the updated edition of the model law was 2006, I guess, whatever. Not the 85, but the newer one. Actually, I think it's in Article 17. If a state has adopted that updated version of the model law, it does provide for the enforcement of interim awards. So that's one solution is legislation adopting the updated model law.
And that's the best solution if that can happen, because the rules cannot dictate anything to national courts. When we were drafting the ICC rules, and we can put anything in the rules that the parties can agree to, because the rules are incorporated by reference into their contract. So there's a party agreement to anything that's in the rules. But the parties can't agree that a particular national court will recognize an emergency arbitrator's order, and the rules cannot impose anything on the courts. So the solution has to come from somewhere else, not from the rules. And clearly the model law and adopting the model law by the vast majority or all of the relevant states would solve that problem.
It's certainly not a fix, but emergency arbitrator state in the award that it is intended to be judicially enforceable. Again, the court's not bound by that, but sometimes there's a question, well, this is interim, it's not a final award. Just not, but I think I've served as an emergency arbitrator a couple of times, and I always put language to that effect in the award.
Well, it always helps. It creates a psychological factor. But as you say, Glenn, quite correctly, it doesn't bind the courts. And the courts sometimes, in some jurisdictions, it gets into semantics. Now, in the ICC rules, the emergency arbitrator decision is called an order. It's not called an award, because in ICC we decide, well, it doesn't conform to what an award is under the ICC rules. And some tribunals have taken state courts have taken the view, well, we don't enforce orders, we can only enforce awards. So you get into that semantic bind. And then you have other courts that say, yes, we enforce awards, but only if they're final. And of course, the emergency arbitrator's decision, I think it's important to point this out, the arbitral tribunal, once constituted, can overturn what the emergency arbitrator did. So it definitely is not final. It's not a final order at all. It's interim relief. So those are some of the things that cause the problems in certain national jurisdictions.
I think it was come unstuck, if you ask me, when it comes to the issue of what is a final award. A lot of local, different countries will have issues with that. But I think maybe to also just answer the question that was asked, when we seek the orders from the emergency arbitrator, yes, of course, we certainly do look to cover up that risk by speaking to the local lawyers in respect of enforcement and what we should do. Should we even go through the pedantic steps of following service requirements that are applicable in that local voluntary, etc., etc. But the ultimate stick is voluntary compliance. And the stick essentially is that if you have a AAA emergency arbitration award, if you have an SIDC emergency arbitration award, and if the respondent feels brave enough to essentially start taking these enforcement points, essentially not complying with it, you can imagine what their position may well be when the arbitration tribunal proper is constituted. And certainly when we've had issues like this in the past, what I do explain to clients is, let's get this tribunal constituted in, let's pay the deposits that are needed, and let's get this moving. Because that is probably, if you ask me, the real threat. If you can create that threat and that hazard for a disobedient respondent, and then slowly they begin to realize it when they speak to their own lawyer, that the full tribunal may not be pleased with you may well see your and the enforcement issue may be secondary after that.
Well, I think that's exactly right. And in fact, if you are a claimant in genuine need of urgent interim relief, you basically have three choices open to you. You can go straight to a state court and seek to get that relief from a state court having jurisdiction. You can wait until, as Chanaka was saying, you can wait until the arbitral tribunal is constituted and then ask for it, assuming that it's not so urgent that you need to do it before the arbitral tribunal is constituted. Because if that's the case, you won't get the emergency arbitrator relief anyway. Or you can go to the emergency arbitrator procedure. Now, it's important to realize, if you go to the state courts, there are certain advantages. You can get enforcement directly through the state courts, and you don't have to worry about this problem about enforcing the emergency arbitrator's order or award. Often in state courts, you can begin the procedure ex parte and even get an ex parte attachment. In French, a saisie conservatoire, and then after that, the other side is notified, they can come in and it may get lifted, but you can go in and get something ex parte in a court. You can't get that from an emergency arbitrator. And also a court can give you measures that can affect third parties, whereas because of the arbitration agreement, consent, and so on, you won't be able to affect third parties. On the other hand, with the emergency arbitrator procedures, you'll have confidentiality, which you won't have in the state courts, typically. And also, many parties have concerns in particular situations as to whether state courts will be impartial, and so they may prefer the emergency arbitrator proceeding. And in the emergency arbitrator proceeding, as Chanaka was saying, you're assured of a very quick result, usually 15 days. And also, you're not dependent upon often rather complex and intricate procedural rules that you have to follow if you're seeking provisional measures before a state court. So you have to weigh the pros and cons and see which is the best approach. Emergency arbitrator or state courts, or if it's not that urgent, ask the arbitral tribunal for it. And then the arbitral tribunal, if it grants such an order, could do it as a partial award, which would be much more easy to enforce than an emergency arbitrator's order or award.
Thank you very much.
Other questions, guys?
Yeah, I just one observation. I've actually done all three. I've actually been counsel, I've been the emergency arbitrator, and then I have one case, and actually my co-arbitrator in that case is here, Christoph Seefarth, where we're the merits panel, and we have an emergency award that was rendered before we were appointed. But my experience as an emergency arbitrator is that sometimes the parties haven't really talked to one another well enough. Is that effectively what you're doing is clarifying in some cases either a misunderstanding as to the party's intent, or at least in one case where I had a party, the respondent effectively, they took the position, well, no, that's not what we meant. We're actually going to deliver the product. And so it all kind of was, well, if that's what your position really is, and I'm going to memorialize it in this order, et cetera, then there's really no basis for emergency relief. But sometimes just because of the speed of things and because it's an emergency, it almost seems that the facts are still being developed, are still occurring. It's all happening in real time, that effectively just getting a meeting of the minds or a de facto settlement just by the parties, in at least that one case, changing what it is they said, or at least clarifying what they said they meant. I see a chat from Christoph that he's still muted.
Right.
How can we do something
Well, it
about
looks like
that?
he's
Yeah,
unmuted.
I don't know. Can you hear me?
We
Yes.
can't,
Yes.
Christoph.
Ah, okay. You can't see me, but you hear me. Thanks, Glenn, for referring to that. I was also involved in an emergency arbitration as counsel for respondent. And I found this very stressful, but very useful. And I'm also a member of the International Distribution Institute. And we think that emergency arbitration may be quite helpful with regard to some basic questions which are of essential significance for the parties. So for example, you have an ongoing business relationship, one party terminates a distribution agreement, and the only question is whether the termination was effective or not. I fear that my case was under the ICC emergency arbitration rules, that the ICC would not agree to take over the case even if the parties agree to that. What is your opinion on that? If both parties agree that a specific legal issue should be decided under emergency arbitration because the case is so important to them, do you think that should be maintained, that should be allowed?
Well, the problem is this, that the emergency arbitrator procedures are not designed to be some kind of mini arbitration, as I said. And so you can't use emergency arbitrator procedures unless you meet the threshold admissibility requirements, that there's something that's urgent that can't await the constitution of the tribunal. Now, in the case you indicate, you could make a case, the parties jointly could make a case that it is so urgent, and they both agree to that because the one party wants the tribunal to order the status quo of the distribution agreement and not allow it to be terminated until the tribunal decides, whether it can be correctly terminated, and that could be urgent. And there are situations where a company could even go into bankruptcy because an agreement is so-called terminated and the other side stops performing under it. And then in the end, the tribunal decides, no, it was not a valid termination. So, I mean, there could be situations where you'd meet the threshold requirements and the type of case you're talking about, but you'd still have to meet the requirements because this is the whole point about what the promise is and what the promise isn't. It isn't really designed to be a separate kind of small arbitral procedure.
It's not, the intention is it's not meant to be essentially a fast track procedure either.
Right, exactly.
It moves fast, quickly, but that's not that's just a feature of it. But it does something very different, and it's just very hard to disturb that.
I mean, if you want a fast track arbitration, you should ask for that. And if the parties jointly, go to the ICC and say, we jointly ask for a fast track arbitration where the tribunal will make every best effort to decide the case in a month, you can do that. But you have to choose the right tool from the toolbox. And the emergency arbitrator tool is not designed to be a fast track arbitration.
I'm curious what the experience has been on how quickly it has moved. What's sort of the slowest that you've seen?
Well, the ICC statistics that I've seen has indicated that, you know, these cases in the very vast majority have been decided close to the 15 days.
I have had one which took 3.5 weeks.
3.5 weeks.
3.5
Which set of rules was it?
Well,
Chanaka?
they put it this way: the institute was not happy at all, and also the person who was appointed as an emergency arbitrator, as I understood, was never invited again to be appointed as an emergency arbitrator. So but the average I see it's very unusual for it to be 2 weeks, certainly.
Yeah.
It's 10 days tends to be the
If I may contribute, my case was exactly 15 days. Started Friday morning. We had a deadline to respond. I extended that from Sunday evening to Monday evening. Then we always had switching deadlines of 48 hours. And the award was rendered 2 weeks later, Friday, 3 o'clock in the afternoon under ICC. I mean, we won, but I think both parties were very pleased with the service and happy with the reasoning.
And what happened next, Christoph? Did they comply?
Yeah,
or I can't recall. Did you get the relief? Were you the claimant or the respondent?
No, I was respondent, so the other party didn't get the relief. But
Well, of course.
they started arbitration, and wonder, this is 2 years ago, the arbitration is still going on. So it didn't really help the case, but it was a good finding. The other party, as always, wanted to draw a bank guarantee, and we fought against that.
Do you think that the denial of the relief affected at all the perceptions of the arbitrators about the case, the merits tribunal?
I think so, yes. But I'm not into the case any longer, but I think so, yes, from what I heard. It's a very useful tool, and everyone I talked to who participated in that was happy, although it's really extremely stressful. But it serves the purpose.
Yeah, it's particularly stressful often for respondents because, you know, they may not even be aware that a dispute is going to go forward. And suddenly one day they wake up and they're hit with an emergency arbitrator procedure and it's going to take 15 days. They don't even know what the issues are yet. The lawyers don't know. So it can be quite stressful for respondents, but that's in the nature of the emergency situation. And presumably, if respondents have done something that requires such urgent relief, they probably should have some idea about it, you would think.
Well, I've also, in my experience as well, I found the unsuspecting respondent would say, look, I've done LCIAs, I've done ICCs, and they see the claimant struggling before they become a claimant, and then they say, it's going to be 1.5 years before they can get us. And then, of course, it's nothing but with greatest pleasure that I the prospect that judgment day will probably come for about 15 days from now. Once But the thing is, it's an education thing, because you can be rest assured that the people we surprise, the respondents we surprise, will probably even take advice on the opt-out procedures going forward. Will probably understand better what it means to put an LCIA clause, SIC clause in, the full ramifications of it. So, but I certainly over the last 10 years, I can tell you I've consistently been with rather surprised respondents.
I mean, I must admit that I suspect that many parties that put ICC clauses in their contracts these days don't realize that if they don't specifically opt out, they're subjecting themselves to a possible emergency arbitrator procedure. Of course, it's their own fault. And their lawyers, their counsel, they themselves, all they need to do is read the rules. It's black and white. It's very clear. And even in the model clauses, it says, if you want to opt out, here it is. We draft it for you. So, I mean, you can't have too much sympathy for that. But at the same time, it probably does happen.
It's the 2 a.m. clause, Peter. It's the 2
I know. I know.
Everybody goes on the website, cuts and pastes it, put it in the contract, and then we move along. Or they use something from 20 years ago. So,
Right.
Mm.
time-wise, not to hold everybody up in respect to their last session, if I'm not wrong, I believe that's our time. Am I right, Peter?
Yeah,
I think
you're out
so.
of time, but there is a question in chat that you may want to hit before you.
Right.
Well, we can answer it now unless the guillotine cuts us off somehow.
No, we're quite happy to answer this.
What is the question?
Is the question is, I have a question. Can a party initiate the emergency arbitration procedure simultaneously in two arbitration tribunals that are competent according to the arbitration agreement? So what you have there, Alexander, I take it you, for whatever reason, you're not coming through on the audio?
Yeah, he says that he can't unmute. I don't know if maybe you can unmute him.
I'm really sorry.
Click on his name. Maybe click on his name and unmute him.
Alexander, is that working?
There, it looks like he's unmuted.
Good afternoon. I'm really happy to be here. So I'm a student and sorry for this question if it is like really on a basic issues because I'm not a lawyer, I'm just a student and I have this question.
Not a
Like,
problem. A pleasure, it's not a problem.
Thank you. Yeah, I can repeat it. Like, can a party initiate the emergency arbitration procedures simultaneously in two arbitration tribunals if they are competent according to the arbitration agreement?
Well, let me try to clarify what I would understand from this. If you have two different claims or two different disputes, they can be handled in one arbitration if they're pursuant to the same arbitration agreement. If you have two different arbitration agreements that cannot be joined in a single suit, then you'll have two arbitrations, and you could have an emergency arbitrator for each if you have a separate need for an urgent relief with respect to each one of the arbitrations. But typically, I must say, I've never seen an arbitration agreement that in itself provides for two different arbitral tribunals being involved in resolving disputes under the same contract. I have seen contracts which say that some disputes will be resolved by experts and others by the arbitral tribunal, but the disputes that would have to be resolved by experts would not per se be subject to the emergency arbitrator provisions. You'd still have to bring the arbitration on something. I don't know if that helps answer your question, or maybe you can clarify another aspect of it which could help us answer it better.
Yeah, thank you. I think it answers really my question.
Good, good.
Thank you. I believe,
Well,
sorry.
no, go ahead.
Any other questions, guys?
Thank you both for a terrific session.
Thank you, Glenn, for organizing this whole thing so brilliantly.
And thank you, Glenn, from me as well. And I've learned how to unmute now at the minute. And thank you, everyone.
It's not intuitive.
And thank you, everyone, for attending. It was a very pleasure.
Thank you all, and have a good evening or morning or whatever it is, wherever you are.
Thank you very much. Bye.
Bye, everyone.